I'm Lyra Han, 38 years old, and everything changed when I saw the name Ashcroft Holdings versus Consolidated Creditors printed on my federal court docket last Tuesday morning. I stared at those words for what felt like several minutes, wondering if this was some kind of cosmic joke, or if the universe had finally decided to complete a circle that began 10 years ago in a law school library. The irony wasn't lost on me that the family who once called me a gold digger desperate for their money would now be standing in my courtroom, financially ruined and asking for my legal mercy. Before I continue this story, let me know where you're watching from in the comments. Hit that subscribe button and join me as I share how being called worthless led me to hold someone else's worth in my hands. Looking back, I should have seen the warning signs from the very beginning, but when you're 28 years old and struggling to pay for law school with a combination of student loans, scholarship money, and tips from your weekend waitressing job, you don't always have the luxury of being selective about the people who show you kindness. Elias Ashcroft was everything I wasn't during our second year at Northwestern Law. Confident where I was anxious, financially secure where I counted every dollar, connected where I felt like an outsider trying to prove I belonged in a world that seemed designed for people who looked and sounded nothing like me. He had this way of making complex legal concepts seem simple during our study group sessions, not in a condescending way, but with a genuine enthusiasm that made even the most mundane contract law feel important and accessible. Our first real conversation happened during a particularly brutal constitutional law study session in November, when I was struggling with a case analysis that everyone else seemed to grasp intuitively. Instead of the dismissive attitude I'd come to expect from my wealthier classmates, Elias stayed after the group disbanded and walked me through the reasoning step by step, his patience never wavering, even when I asked the same question 3 different ways. "You're thinking about this too hard," he said with a smile that didn't feel patronizing. "Sometimes the law is exactly as straightforward as it appears to be." That night, for the first time since starting law school, I felt like maybe I did belong there. Like maybe the admissions committee hadn't made a mistake when they offered a scholarship to a first-generation college student whose parents still weren't entirely sure what lawyers actually did for a living. The early months of our relationship felt like stepping into a different version of my life, one where stress about money took a backseat to conversations about cases and career aspirations, where someone actually wanted to hear about my day instead of just tolerating my presence. Elias had this way of making me feel intellectually valued that I'd never experienced before, asking thoughtful questions about my perspectives on cases and genuinely listening to my responses like they mattered. He'd pick me up after my weekend shifts at the restaurant without complaint, never making me feel ashamed about smelling like French fries and exhaustion. And he'd often bring me dinner from places I couldn't afford, casual gestures that felt enormous to someone who was used to choosing between textbooks and groceries. When he first mentioned bringing me home to meet his family during spring break, I felt a mixture of excitement and terror that kept me awake for several nights. Everything I knew about the Ashcrofts came from casual mentions during our conversations, references to family business dealings and vacation homes that painted a picture of wealth I'd never encountered personally. "They're going to love you," Elias assured me when I expressed my nervousness about fitting in, but there was something in his tone, a slight hesitation that I chose to ignore because I wanted so desperately to believe that love could bridge the gap between his world and mine. The week before the visit, I spent money I didn't have on a new dress and shoes, wanting to make the right impression, trying to transform myself into someone worthy of their son's affection and their family's approval. The Ashcroft estate in Lake Forest was everything I'd imagined and worse. A sprawling property that screamed old money and established power, the kind of place where even the landscaping looked expensive and deliberately maintained. As we pulled through the iron gates and up the circular driveway, I could feel my confidence shrinking with each perfectly manicured hedge we passed, and by the time we reached the front door, I was questioning every choice I'd made, from my outfit to my decision to come at all. Elias squeezed my hand as we walked toward the entrance, but I could sense his own tension building, a subtle shift in his demeanor that suggested this introduction carried weight for him too, though probably not the same kind of terror that was currently making my palms sweat and my stomach churn with anticipation of judgment I wasn't sure I was prepared to face. The first dinner at the Ashcroft house established a pattern that would define the next 8 months of my relationship with Elias. A careful dance of polite conversation, punctuated by moments of subtle cruelty that left me questioning whether I was being overly sensitive or accurately reading the room. Margot Ashcroft greeted us at the door with the kind of smile that never quite reached her eyes, the practiced expression of someone who had perfected the art of appearing welcoming while maintaining emotional distance. "So, you are the law student Elias has been telling us about," she said, her gaze taking in my carefully chosen outfit with an assessment that felt more like an appraisal than genuine interest. "How interesting that you're working your way through school. That must be so challenging." The word challenging carried a weight that suggested she found my circumstances more pitiable than admirable, and I spent the rest of the evening wondering if every compliment contained a hidden barb I was too inexperienced to detect. Reginald Ashcroft was more direct in his approach, asking pointed questions about my family background and career aspirations that felt less like getting-to-know-you conversation and more like a job interview for a position I wasn't sure I wanted. "And what does your father do?" he asked during the appetizer course, his tone suggesting he already knew the answer wouldn't meet his standards. When I explained that my dad worked in maintenance for the city and my mom cleaned office buildings at night, the silence that followed felt loaded with judgment, broken only when Margot changed the subject to ask about my plans after graduation. "Public defense work sounds very noble," she said, with a kind of tone people use when they're trying to be supportive of something they consider beneath them. "I'm sure there are people who really need that kind of help." The implication that I would naturally gravitate toward the less prestigious aspects of legal work because of my background wasn't lost on me, but Elias either didn't notice or chose not to address it, leaving me to navigate the subtle slights alone. Tamsin, Elias's younger sister, had a different approach to making me feel unwelcome, one that involved befriending me just enough to deliver calculated insults disguised as helpful observations. "You know, Lyra, you have such interesting style choices," she said during one of my visits, fingering the fabric of a sweater I'd bought at Target like she was examining an artifact from another culture. "It's so authentic and real. I could never pull off shopping at those kinds of places." Her compliments always contained poison, observations about my natural beauty that suggested I was lucky to look good without expensive products, or comments about my refreshing perspectives that implied my opinions were charming in their simplicity. She had this way of making me feel like a curiosity rather than a person, someone to be studied and discussed rather than genuinely known, and her presence at family gatherings added another layer of stress to interactions that were already fraught with tension. The holidays were particularly brutal, family traditions that highlighted every way I didn't belong in their carefully curated world of private clubs and inherited wealth. Christmas dinner at the Ashcroft house was a formal affair, with multiple courses, crystal glasses, and place settings that required knowledge I'd never needed before. I watched Elias navigate the various forks and serving dishes with practiced ease, while I tried to follow his lead without appearing obvious about it, but Margot noticed everything, offering helpful corrections about proper etiquette that felt more like public humiliation than genuine assistance. "Oh, darling, the salad fork is the smaller one," she said with exaggerated patience when I reached for the wrong utensil, her voice carrying just enough volume to ensure everyone at the table was aware of my mistake. "These things can be so confusing when you're not used to formal dining." The comment hung in the air like an accusation, and I spent the rest of the meal hyper-aware of every movement, every bite, every potential opportunity to reveal my inadequacy. Spring break became another battlefield, a family vacation to their house in the Hamptons that I couldn't afford to join but felt obligated to attend when Elias offered to pay my way. The gesture felt generous until I realized it came with the expectation that I would be grateful enough to overlook the constant commentary about my lack of familiarity with their lifestyle. "Lyra's never been sailing before?" Margot announced to their friends at the yacht club, her tone suggesting this was a charming character flaw rather than simply a different life experience. "Isn't that sweet? She's learning so much from Elias. I became a project rather than a partner, someone to be improved and educated rather than accepted as I was, and the constant scrutiny left me exhausted and questioning whether love was supposed to feel this much like a performance you were constantly failing." The breaking point came during a dinner party in late April, when Margot had been drinking enough wine to lower her usual filter of polite cruelty. One of their family friends, a woman who introduced herself with 3 names and a pedigree that included multiple generations of Chicago society, was discussing her daughter's recent engagement to someone from a good family. The conversation naturally turned to the importance of marrying within one's social circle, the challenges that arose when people from different backgrounds tried to build relationships, and the wisdom of parents who guided their children toward appropriate partners. Of course, some people are just attracted to money, the friend said with a meaningful glance in my direction. It's natural for young women from struggling backgrounds to see wealthy families as a solution to their problems. Margot nodded thoughtfully, her eyes fixed on me as she agreed that gold diggers were a constant concern for families like theirs. People who would say anything and pretend to be anyone if it meant access to financial security they couldn't achieve on their own. I looked at Elias, waiting for him to defend me, to contradict the narrative they were constructing about my motivations and character, but he sat frozen in his chair, his eyes focused on his wine glass like it contained the answers to questions he didn't want to ask. The silence stretched on until it became clear that no defense was coming, that the man I'd fallen in love with was going to let his mother and her friend tear apart my character without consequence. "Excuse me," I said, standing from the table with as much dignity as I could manage. "I need some air." I walked outside to their perfectly landscaped garden and called Rhea to pick me up, knowing that whatever happened next, I couldn't continue to subject myself to a family that saw me as a threat to be managed rather than a person to be welcomed, and that I couldn't stay with someone who would watch me be humiliated without lifting a finger to stop it. The apartment I moved into after leaving Elias was a studio in Rogers Park that smelled faintly of the previous tenant's cats and had a radiator that clanged like it was trying to communicate in Morse code, but it was mine, in a way that nothing had been for months. The rent ate up most of my waitressing income, leaving me with enough money for ramen noodles and law school textbooks, but not both in the same week. So I learned to prioritize in ways that left my stomach empty and my mind full of contract law and constitutional theory. Rhea helped me move my few belongings in 2 trips, her small Honda Civic loaded with boxes that contained everything I owned, and she didn't ask questions about why I was crying while folding my clothes into a dresser I'd bought at Goodwill. "You're going to be okay," she said, but the words felt hollow in the empty space that echoed with every footstep, and I wasn't sure either of us believed them. The hardest part wasn't the loneliness or the financial stress, but the way my concentration fractured in the weeks following the breakup. My ability to focus on studies compromised by a constant replay of every moment I should have defended myself, every silence I should have filled with my own voice, instead of waiting for someone else to speak up for me. Professor Silas Wendell noticed my declining performance during his advanced civil procedure class, my usually sharp contributions to discussions replaced by distracted stares out the window, and he asked me to stay after class one Thursday in early May. "Ms. Han, your work this semester has been inconsistent," he said, his tone more concerned than critical. "Is there something affecting your studies that we should discuss?" I found myself telling him everything: the relationship, the family, the humiliation, the way I'd let other people's opinions of my worth become my own internal narrative of inadequacy. Professor Wendell listened without interruption, occasionally nodding but never offering the platitudes I expected, and when I finished, he was quiet for several moments before speaking. "The law has a way of attracting people who've been underestimated," he said finally. "Some of our best advocates are those who understand what it feels like to have your voice dismissed, your perspective minimized." He offered me a research position for the summer, working on a project about economic inequality in the justice system, paying enough to cover my rent and groceries while giving me experience that would strengthen my resume for judicial clerkship applications. "Consider this an investment in someone who has something important to contribute," he said, and for the first time in months, I felt like someone saw potential in me rather than problems to be solved or deficiencies to be overlooked. The research work became my sanctuary, long hours in the law library analyzing case law and economic data that painted a clear picture of how financial status affected legal outcomes, how people like my parents faced systemic disadvantages in a system that claimed to provide equal justice regardless of economic circumstances. I found myself developing expertise in areas that prestigious law firms rarely touched: consumer protection law, housing rights, predatory lending practices. the unglamorous legal work that actually affected people's daily lives, rather than corporate bottom lines. My summer research paper on bankruptcy proceedings and their disparate impact on working-class families caught the attention of several professors who encouraged me to submit it for publication in the Law Review. My first step toward building a reputation based on my own work rather than my ability to fit into someone else's expectations. Third year brought opportunities I hadn't dared to hope for during those dark months after the breakup. A federal clerkship interview that Professor Wendell had recommended me for, despite my grades being good but not exceptional, my background being relevant but not prestigious. Judge Catherine Morrison was known for her sharp intellect and her impatience with lawyers who came to her courtroom unprepared. But she also had a reputation for fairness that attracted cases involving constitutional issues and civil rights violations. "Your research on economic justice impressed me," she said during my interview, discussing my work with a seriousness that made me feel like a scholar rather than a charity case. "I need clerks who understand that the law affects real people, not just legal principles." When she offered me the position, starting after graduation, I felt like I was finally building something that belonged to me, rather than trying to squeeze myself into spaces designed for other people. The clerkship year was transformative in ways I hadn't anticipated. Exposure to complex legal reasoning and high-stakes litigation that challenged every assumption I'd held about my own capabilities and the legal system's potential for both justice and harm. Judge Morrison became an unofficial mentor, critiquing my draft opinions with precision, but also encouraging me to develop my own analytical voice, to trust my instincts about fairness and constitutional interpretation. "You have good judgment, Lyra," she told me during one of our weekly review sessions. "Don't let anyone convince you that your perspective is less valuable because you've lived experiences that others haven't." She recommended me for a position at the U.S. Attorney's Office, prosecution work that would give me trial experience and courtroom confidence, stepping stones toward the judicial career I was beginning to envision for myself. The prosecutor's office introduced me to a different kind of legal work, cases involving white-collar crime and financial fraud that often targeted people from backgrounds similar to my own, elderly couples who lost their retirement savings to investment scams, small business owners destroyed by predatory lending practices. I found myself particularly effective at connecting with witnesses and victims who were intimidated by the legal system, people who saw me as someone who might actually understand their struggles rather than judge them for their financial vulnerability. My conviction rate was strong, but more importantly, I was building a reputation for thorough preparation and empathetic advocacy that caught the attention of federal judges who worked with our office regularly. After 3 years as a prosecutor, when Judge Morrison mentioned that she was planning to recommend me for a judicial appointment, I realized that the path I'd stumbled onto after being rejected by the Ashcroft family had led me exactly where I needed to be, even if I hadn't known that's where I was headed. The federal judicial nomination process at 35 felt surreal. Months of background checks and interviews that dissected every aspect of my life from law school grades to personal relationships, scrutiny that would have terrified the younger version of myself who had worried so much about other people's approval. The Senate Judiciary Committee hearing was particularly intense, senators asking pointed questions about my prosecutorial record and judicial philosophy, while I sat at a table that felt both enormous and confining, knowing that this moment would determine whether I became one of the youngest federal judges in recent history. Judge Han, Senator Williams asked during the final round of questioning, "What experiences have shaped your understanding of justice?" I found myself talking about growing up watching my parents work multiple jobs, about understanding how the legal system looked different depending on your economic circumstances, about the responsibility judges have to ensure that courtroom dignity extends to everyone, regardless of their background or bank account. The confirmation vote passed with a comfortable margin, but the real validation came from the swearing-in ceremony 6 months later, when I stood in the same federal courthouse where I'd clerked for Judge Morrison, surrounded by colleagues and mentors who had believed in my potential when I couldn't see it myself. My parents sat in the front row, my father uncomfortable in the suit we'd bought him for the occasion, my mother crying quietly as I took the oath of office that made me the Honorable Lyra Han, United States District Judge. Rhea had flown in from San Francisco where she worked in tech now, and Professor Wendell was there with several of my former colleagues from the prosecutor's office, a chosen family that had formed around shared respect rather than blood relations or social obligation. Judge Morrison administered the oath, her voice steady as she spoke the words that officially transferred the authority I'd worked 7 years to earn, the power to make decisions that would affect people's lives in ways both profound and permanent. The early months on the bench were a constant learning curve. Civil cases involving contract disputes and personal injury claims, mixed with criminal matters that required swift decisions about bail and sentencing, each ruling a reminder of the weight that came with the black robe and elevated position. My first major case involved a class action lawsuit against a payday lending company that had targeted low-income communities with predatory interest rates, exactly the kind of financial exploitation I'd studied during my research with Professor Wendell years earlier. The plaintiff's attorney was competent but overwhelmed by the defense team's resources. Corporate lawyers who tried to bury relevant documents under mountains of irrelevant paperwork. Tactics designed to exhaust the other side's ability to pursue justice. I found myself drawing on my background in ways that felt both personal and professional, understanding viscerally how intimidating the legal system could be for people who were already struggling financially, how easily justice could be delayed or denied through procedural manipulation. Word about my judicial style spread quickly through the legal community, lawyers discovering that Judge Han's courtroom operated with efficiency and fairness, but little tolerance for games or grandstanding, that I expected thorough preparation and respectful treatment of all participants regardless of their economic status or legal representation. My docket filled with increasingly complex cases, federal prosecutors bringing white-collar criminal matters that often involved sophisticated financial schemes designed to separate people from their money through elaborate frauds and market manipulations. The irony wasn't lost on me that I was now the person with the power to hold wealthy defendants accountable for the same kind of predatory behavior that had once made me feel small and worthless, though I was careful to ensure that my personal experiences informed my judgment without compromising my objectivity. 3 years into my tenure, I began noticing a pattern in the bankruptcy cases that crossed my desk. An increasing number of family businesses and individual entrepreneurs filing for protection from creditors as the economy shifted and traditional business models struggled to adapt. The cases told stories of overextension and poor decision-making, but also of changing markets and technological disruption that had left many established companies scrambling to reinvent themselves or face financial ruin. Some of the petitioners were sympathetic figures, small business owners who had mortgaged everything to pursue entrepreneurial dreams, while others were wealthy individuals who had leveraged their assets irresponsibly and were now seeking legal protection from the consequences of their choices. Each case required careful analysis of financial records and debt structures, determining which creditors would be paid and in what order, decisions that could mean the difference between a fresh start and complete financial devastation. The morning I saw Ashcroft Holdings versus Consolidated Creditors on my docket, I had to read the name 3 times before it fully registered, my coffee growing cold as I stared at the familiar surname that I hadn't thought about in months. My first instinct was to recuse myself from the case, to pass it to another judge who could handle it without the emotional complications that came with my history with the Ashcroft family. But professional curiosity made me request the initial filing documents to understand the scope of their financial collapse. The papers told a story of poor investments and market miscalculations, real estate ventures that had soured when property values declined, technology investments in companies that had failed to deliver promised returns, a pattern of overconfidence and inadequate risk assessment that had gradually eroded the family's wealth over several years. According to the financial disclosures, Ashcroft Holdings owed nearly $40 million to various creditors, their assets worth significantly less than their debts, a classic case of insolvency that would require careful management to ensure fair distribution of whatever value remained. The company that had once seemed so powerful and established, the source of wealth that had made the Ashcroft family feel superior to people like me, had been reduced to columns of numbers that told a story of financial ruin and mismanagement. Reginald Ashcroft was listed as the primary defendant, with Margot and their children named as secondary parties due to personal guarantees they had signed on various business loans, their personal assets, now vulnerable to creditor claims that could strip away the lifestyle and status that had once seemed so permanent and unshakable. I spent that evening reviewing the ethical guidelines for judicial recusal, researching precedents and consulting with senior colleagues about the appropriate way to handle a case involving people from my personal past, though I was careful not to reveal the specific nature of my connection to the defendants. The consensus was clear. Personal relationships with parties required recusal, but past social acquaintance that didn't involve ongoing contact or financial interest might not disqualify a judge if the relationship was disclosed, and no bias could reasonably be perceived. As I sat in my home office surrounded by law books and case files, I realized that the universe had presented me with an opportunity that felt almost too poetic to be real. The chance to preside over the financial ruin of the family that had once dismissed me as unworthy of their son's love and their social circle's acceptance. The morning of the Ashcroft Holdings bankruptcy hearing, I arrived at the courthouse earlier than usual, needing extra time to review the case files and prepare myself emotionally for what would either be the most professional challenge of my judicial career or the most personal test of my character since taking the bench. The financial documents painted a devastating picture of systematic mismanagement, failed real estate ventures and markets the family clearly didn't understand, technology investments that revealed a fundamental lack of due diligence, and personal spending that had continued at unsustainable levels even as their business empire crumbled around them. By 8:30 a.m., I was seated in my chambers staring at the framed photo of my swearing-in ceremony while trying to reconcile the confident federal judge I'd become with the insecure young woman who had once desperately wanted this family's approval. The defendants entered my courtroom at exactly 9 o'clock IME, and the 10 years since I'd last seen them had not been kind to any of the Ashcrofts. Their expensive clothing unable to hide the stress and exhaustion that marked their faces, like a roadmap of recent struggles. Reginald looked significantly older, his formerly commanding presence diminished by the weight of financial ruin and legal proceedings. His shoulders stooped in a way that suggested he was carrying more than just the burden of debt. Margot walked beside him with the rigid posture of someone fighting to maintain dignity in circumstances that had stripped away most of her sources of pride, her designer handbag and jewelry, the last vestiges of a lifestyle that the bankruptcy proceedings would soon dismantle piece by piece. It was Elias who noticed me first, his eyes widening with recognition that quickly shifted to something approaching horror as he realized that the woman his family had once dismissed as a gold digger was now the federal judge who would determine their financial fate. He whispered something to his father, who looked up at the bench with confusion before understanding dawned across his features, the terrible irony of their situation becoming clear as they took their seats at the defendant's table. Margot was the last to recognize me, her face cycling through surprise, disbelief, and finally a kind of resigned despair as she understood that the young woman she had humiliated at dinner parties now held the power to approve or deny their petition for bankruptcy protection. The hearing proceeded with the formal precision that federal court required, the Ashcroft's attorney presenting their petition for Chapter 11 reorganization, while creditor representatives argued for liquidation of assets to maximize recovery of outstanding debts. I listened to each argument with the professional detachment I'd cultivated over 3 years on the bench, asking clarifying questions about asset valuations and debt structures while carefully avoiding eye contact with the defendants who had once made me feel so small and worthless. The irony was almost overwhelming, sitting in judgment of people who had questioned my motivations and character, now reduced to asking for legal mercy from a system they had probably never expected to need. During the lunch recess, as I reviewed additional financial documents in my chambers, my clerk knocked and informed me that Elias Ashcroft was requesting a brief meeting, claiming he had information relevant to the case that he could only share with me directly. Professional protocol suggested I should decline the meeting or require his attorney to be present. But curiosity about what he might possibly have to say made me agree to 5 minutes in my chambers with the court reporter present to document any substantive discussion. He entered my office looking like a man who had aged far more than the 10 years since our relationship ended, his confident demeanor replaced by the nervous energy of someone whose world had fundamentally shifted in ways he was still struggling to understand. "Your Honor," he began, the formal address strange coming from someone who had once whispered my name in law school library study rooms. "I want you to know that I understand the position this puts you in, and if you feel the need to recuse yourself from our case, my family would understand." His voice carried a humility I'd never heard before, the arrogance and entitlement that had once marked his personality, worn away by circumstances that had forced him to confront his own limitations and failures. "I also want you to know that I've thought about you often over the years, about how badly my family treated you, about how I failed to defend you when you needed me to." The admission hung in the air between us. Years of unspoken regret finally given voice in circumstances neither of us could have imagined. I maintained my judicial composure while internally processing the strange satisfaction of hearing him acknowledge what I had always known, that his family's treatment of me had been cruel and his silence had been a betrayal of everything I thought we meant to each other. "Mr. Ashcroft," I replied, using his formal name to maintain the necessary distance, "this court will handle your family's case with the same fairness and attention to legal precedent that every petitioner receives, regardless of any personal history that may exist." His shoulders sagged slightly at my professional tone, and I could see him struggling with the reality that the woman he had once known was now fundamentally beyond his reach. Protected by judicial authority and personal growth that had transformed me into someone he no longer had the power to hurt. The afternoon session focused on the creditors' objections to the reorganization plan, their attorneys arguing that the Ashcrofts had hidden assets and continued to live beyond their means, even as they sought protection from their debts. The evidence was damning. Credit card statements showing luxury purchases and vacation expenses that continued right up until the bankruptcy filing. A pattern of behavior that suggested they viewed the legal proceedings as a way to avoid consequences, rather than genuinely restructure their financial obligations. As I listened to the testimony about hidden offshore accounts and fraudulent asset transfers, I realized that the family who had once accused me of being motivated by money had themselves engaged in exactly the kind of financial manipulation they had projected onto me. When court adjourned for the day, I returned to my chambers to draft the preliminary ruling that would determine whether the Ashcrofts received the bankruptcy protection they sought or faced complete liquidation of their remaining assets. The law was clear about the standards that needed to be met, and the evidence suggested that their petition failed to meet several key requirements for reorganization, particularly regarding good faith efforts to pay creditors and honest disclosure of assets. As I wrote the legal analysis that would seal their financial fate, I found myself thinking not about revenge or personal satisfaction, but about the responsibility that came with judicial power, the obligation to apply the law fairly, regardless of how I felt about the people standing before my bench asking for mercy they had never shown to others. The final bankruptcy hearing took place 3 weeks later, and I had spent that time carefully reviewing every precedent and legal standard that applied to the Ashcroft case, determined that my ruling would be beyond reproach, regardless of any personal satisfaction I might derive from the outcome. The courtroom was packed with creditors and their attorneys, journalists covering what had become a high-profile case due to the family's former prominence in Chicago business circles, and a few curious spectators who had heard about the dramatic irony of a former girlfriend presiding over her ex-boyfriend's family's financial ruin. As I took the bench that morning, I felt the weight of judicial responsibility more acutely than ever before, knowing that the decision I was about to announce would define not only the Ashcrofts' future, but also my own integrity as a federal judge who could separate personal history from legal obligation. The Ashcrofts sat at the defendant's table, looking like people who had already accepted their fate, their expensive attorney having clearly prepared them for the reality that their petition for reorganization was unlikely to succeed, given the evidence of financial misconduct and asset concealment that had emerged during the proceedings. Margot stared at her hands throughout most of the hearing, the woman who had once wielded social status like a weapon, now reduced to hoping for legal mercy from someone she had systematically humiliated and dismissed. Reginald appeared to have aged another 5 years in the 3 weeks since our last hearing, the stress of potential criminal charges for bankruptcy fraud having stripped away the last remnants of his former commanding presence, leaving behind a tired old man who had gambled everything and lost. When I began reading my ruling, the courtroom fell silent, except for the scratch of court reporters' pens and the occasional cough from the gallery, everyone understanding that these words would determine whether one of Chicago's formerly prominent families would have a chance to rebuild or face complete financial destruction. After careful consideration of all evidence presented, I began, my voice steady and professional. This court finds that the debtors have failed to meet the requirements for Chapter 11 reorganization under federal bankruptcy law. The ruling detailed their pattern of asset concealment, continued luxury spending during insolvency, and failure to negotiate in good faith with creditors, violations that made reorganization inappropriate regardless of any sympathy the court might feel for their personal circumstances. However, rather than ordering immediate liquidation as the creditors had requested, I announced that the court would approve a modified Chapter 7 proceeding that would allow the family to retain their primary residence and basic personal assets, while ensuring maximum recovery for creditors from their business holdings and investment properties. The decision was legally sound and represented a middle ground that satisfied the demands of justice while acknowledging that complete destitution served no legitimate purpose under bankruptcy law. The goal of these proceedings, I explained, is to provide fair resolution for all parties while maintaining the integrity of the legal system that protects both debtors and creditors according to established law. As the hearing concluded and people began filing out of the courtroom, I noticed Elias lingering near the defendant's table, apparently waiting for an opportunity to speak with me, despite the impropriety such contact would represent. I instructed my bailiff to clear the courtroom completely, then spent several minutes organizing my papers while processing the strange mixture of professional satisfaction and personal closure that came with concluding a case that had tested every aspect of my judicial temperament. When I finally looked up, the courtroom was empty except for the usual court personnel, and I realized that whatever final conversation Elias might have wanted was probably better left unspoken, our relationship now permanently defined by the formal boundaries of the federal judicial system. 3 months later, I received a brief handwritten note, forwarded through the court's administrative office, a single page of expensive stationery that contained what I recognized as Margot Ashcroft's distinctive handwriting despite not having seen it in over a decade. "Your Honor," the letter began, "I want you to know that your handling of our case was fair and professional, and that I have spent considerable time reflecting on my behavior toward you during Elias's law school years." The note continued with what appeared to be a genuine apology for the cruelty and condescension she had shown me, an acknowledgement that her treatment of me had been motivated by prejudice and insecurity rather than any legitimate concerns about my character or motivations. The letter's final paragraph surprised me with its honesty and self-reflection. Margaret admitting that losing their wealth had forced her to confront how much of her identity had been built on financial status rather than personal worth, and how the humiliation of bankruptcy had given her a small taste of what I must have felt during those family dinners and social gatherings, where I was made to feel inferior and unwelcome. "You have built something admirable with your life," she wrote, "and I hope you can find some satisfaction in knowing that the young woman we underestimated has become someone whose integrity and accomplishment command respect." I read the letter twice before filing it away, recognizing it as the closest thing to genuine accountability I was likely to receive from someone who had spent years treating me as less than human. As I reflected on the entire experience that evening, sitting in my home office surrounded by legal briefs and case files that represented the career I had built from nothing, I realized that the Ashcroft bankruptcy case had given me something more valuable than revenge or vindication. It had proven to myself that I could face the people who had once made me feel worthless and maintain both my professional integrity and personal dignity, that the federal judge I had become was strong enough to separate past pain from present responsibility. The scared young woman who had left that dinner party in tears 10 years earlier had been replaced by someone who understood that true power came not from the ability to inflict pain on those who had hurt you, but from the strength to rise above their limitations and build something meaningful with your life. The years that followed brought other challenging cases and difficult decisions, but none that tested my character quite like the morning I saw the Ashcroft name on my docket and realized that sometimes the universe does have a sense of justice, even if it takes a decade to reveal itself. I never saw any members of the Ashcroft family again after that final bankruptcy hearing, but I occasionally wondered if they had learned anything from their fall from privilege, if losing everything had taught them the same lessons about resilience and self-worth that being abandoned by them had eventually taught me. Looking back now, I can honestly say that being called a gold digger and dismissed as unworthy was the best thing that ever happened to me, because it forced me to discover who I really was when stripped of other people's expectations and approval, and that person turned out to be someone I could respect and be proud of, regardless of what anyone else thought about my worth or my place in the world.